And finally, the judge speaks at length about the qualifications of the experts themselves. Now, I've been very careful not to tell you who the experts are. Dr. X is well known in the statistical community, and the judge argues that Dr. X quite properly asks why the dummy coefficient mode was used. The issue here is whether or not you do separate regressions for males and females, or whether or not you do a combined regression without interaction terms. That's a fairly subtle issue for a judge to be discussing an opinion of this sort. Dr. Y has testified, he says, that she has a very strong guess that running separate regressions for males and females would not affect the results. No evidence to the contrary of this empirical judgment by an expert was presented. The judge notes that Dr. Y is not a statistician, but rather an expert in labor economics who was familiar with the relevant empirical work. And he concludes Dr. X is an impressive expert on statistical issues, but not as to labor economics issues, and he accepted the evidence from Dr. Y, despite the fact that it was really quite faulty. And his concluding words in finding for the plaintiffs on several but not all of the issues. What he went through is in the case where the plaintiffs didn't handle proxy variables properly, he threw out the statistical evidence in those cases. So he went through piece by piece and adjudicated the analyses. But he concludes by noting that the esoterics of econometrics and statistics, which both parties have required this court to judge, have a centripetal dynamic of their own. And the precision-like mesh of numbers tends to make fits of social problems where intuitively I feel none exists. I remain wary of the siren call of the numerical display and hope here that the resistance was adequate, that the ultimate findings are the product of judgment and not calculation. It's a very instructive opinion, and I would encourage you to go look at it. That was the good example. I promised you one of both sorts, because most situations involve judges who are really struggling to keep afloat in the sea of statistical testimony. And I'd like to read you an exchange that comes from a case involving Judge McMillan in Stasny versus Southern Bell Telephone. It's a 1978 case, not all that long ago. And I think that this one may be much more the norm. It's a short exchange. Question. A question comes from the lawyer. The answer comes from the statistical witness who is sitting. So you have to envision the lawyer standing here and the female statistical witness sitting in the box beside the judge. Dr. Keith, these various weights, this is another regression analysis in case you don't identify it, are they weights that you determine or weights that the computer determines? Answer. They're weights that are determined by the computer because the regression equation is obtained through the program that's used. Very informative. Court. How does this theory cope with the absolutely arbitrary decisions that an employer might make to pay one person $5 and another $10 an hour for doing the same work? Answer. We look at the wages for all employees, and these wages are converted to the natural logs, and then, court. What do you mean by natural laws? Not any natural laws about wages. Answer. What happens is that you take a wage. Court. I've been hearing law all afternoon. Natural law. I thought we were getting back to Rousseau. Given this particular exchange, it's not surprising to find that Judge McMillan swept away the regression analyses of both sides with the following statement. Regression analysis begins with the assumption that certain independent variables in fact determine the outcomes of decisions to raise pay and promote. Such assumptions are intellectually questionable and not grounded in any solid evidence. Much of the statistical testimony, especially in these equal employment opportunity cases, either skirts or in effect ignores some rather complex statistical issues. And I did promise you a little weight in here. And there are a lot of things going on there that I think are quite questionable. And if you get called upon to testify or work in any of these cases, I think these are some questions that you should ask yourself. What is the justification for doing a regression analysis and associated tests of significance in the context of complete data for the company in question? We're dealing with a population now, not with a sample, and the question of where regression fits into that is something that at least somebody should raise questions about. Second, that if the analysis can be justified, how should you interpret the coefficients? Especially for those dummy variables, the 0, 1 variables that are associated with sex or minority status. The way they have been interpreted by many is that's the amount of discrimination. I think that's very hazardous in a lot of settings. There is a larger issue that's suggested by some of the things that I've just mentioned, which is whether or not a statistician should present new methods in such settings, because as many of you will have learned, when you face a new problem, old methods may not be appropriate, and you have to develop new methods to suit the problem. The question then becomes, should you present those new methods and innovative analyses as part of your testimony, or should you turn and rely on less appropriate but relatively standard techniques, which the court is more likely to understand? And by now, standard means things like regression analysis, but then it means that maybe you can't use log linear models and logit analyses, and that would be a big shame. Well, I think these are not easy questions to answer, and indeed in any particular case, it's not clear that they have answers at all. As the hour is growing late, rather than regale you with further stories of statistical infelicities and mindless regression analyses involving in excess of 125 predictors, and there is one such case, or give you advice on how to prepare your own testimony for the case that you're currently working on as a statistical expert, let me end with one last story regarding my own testimony in a case about 4.5 years ago involving allegedly faulty merchandise supplied by one company to the next. The merchandise consisted of approximately 4,000 artificial fur collars, and they were packed into 70 cartons. And back in 1974, when the defective merchandise was first suspected, the plaintiffs hired a statistician to draw a random sample of 112 collars. Now, why 112, I don't know. And then they sent these collars out to another expert who analyzed them and pronounced them defective or non-defective. The results of that analysis were that 90% of the collars that were selected were deemed defective. Now, we all know how to make inferences from a sample of 112 where the probability of a defect is 90%, and that's a pretty easy thing to do. And so, although I was asked to do that test, I was also, that was the easy part, I also had to deal with a somewhat more difficult problem. The problem was that in the intervening time, the statistician who had drawn the sample had died. And he had a memorandum describing the sampling plan, but unfortunately he never told me what table of random numbers he used and how the selection actually went on. And so the real issue that I had to face up to was how to actually show that the sample was indeed random, and therefore give the court justification for inferring that essentially all of the merchandise was defective. Well, I prepared, in my customary way, a report. And in the report, I did a very elaborate analysis, which, while, as many of you know, you can't prove that a sample is a random one, you can certainly demonstrate that the information that you have is consistent with a sample that would have been drawn at random. And I did this in various ways, and the direct testimony in the case went very, very well. The lawyer with whom I was working, I briefed him this time. I didn't want to get caught with a wrong total. And so he carefully drew out each of the tests I did, including a frequency analysis. And he asked me for a reference on that one, and I reached into my briefcase and pulled out a copy of Bishop Feinberg and Holland and directed the judge to Chapter 9. The defendant's lawyer finally stood up at the end and began his cross-examination as follows. Professor, I nodded my head. I'm sure that the Harvard Business School, where you received your PhD, and answer, my degree is from the Department of Statistics at Harvard, not from the business school. Well, at any rate, I'm sure that you have good training in mathematics. But tell me, Professor, if you were to take an artificial fur collar and scrunch it all up and stuff it into a plastic bag and then throw that bag into a box where it stayed for 3 years, wouldn't you expect it to look like this? And he opened up this plastic bag and he reached in and he pulled out this scruffing-looking fur collar and he stuck it into my face. And I was just sort of sitting there, and I looked at the judge, and the judge looked at me, and I looked at the lawyer who was sitting up at the bench, and he was looking at the fellow's back, and he couldn't see what was going on. I was absolutely speechless, and I hadn't been prepared for this one at all. And then finally, one of the lawyers stood up and objected to this line of questioning, since I was qualified as an expert statistical witness and not an expert witness on fur collars. The judge sustained this objection, and the defendant's lawyer remarked that as far as he was concerned, my statistical testimony had absolutely nothing to do with the realities of the case, and he had no further questions. Fortunately for all of us, statistical testimony has much to do with the realities of enough cases to keep many of us here tonight busy as expert witnesses for years to come. Thank you.
You touched on a theme which I assume is an interesting one. To what extent? No. Let's start that over again. A pervasive one, the matter of whether statistical expertise can live and survive on its own. To what extent you're always vulnerable to this accusation that your statistics may be great, but you don't know anything about what's really going on. How can we, do we need then to go in as a team and as only handmaidens of science, or whatever the right word is, or can we really ever take the full brunt of the responsibility, mostly on the basis of the statistics per se?
It's very, very tricky. One of the things that I've discovered, I've been involved in several cases, most of which I haven't bored you with. And indeed, many of those cases are ones which have never gone to court. One of the wonderful things about the legal system is that it involves both parties in very prolonged negotiations, and there's a reason for 10-year lags, because most of them get settled in that 10-year period. I've learned that what you have to do is work very carefully with lawyers. And I've discovered that my job in a lot of cases is to teach the lawyers about statistics. To teach them often about the limitations of statistics, not to go in and convince them that it will solve all their problems. I think if you go in with the notion that it will solve all the problems in a case, you're in for a big disappointment and for a big, big shock down the line. So if you begin with that kind of attitude, it's much easier. If you get a good lawyer to work with, it's a lot better, especially at the rates that one gets paid as a consultant as opposed to a professor salary to lecture to hundreds of students in a classroom. But then it progresses slowly. You begin to see evidence from the other side, and it becomes abundantly clear that statistics is only part of the case. But at the same time, that's what I learned when I did consulting in other fields. This wasn't new to me when I went into the area of statistics in the law. It's what I learned when I did agricultural field trials with people at Minnesota. I was reading something very interesting that Bill Cochran said and attributed it to, I guess, when he was at Rothamsted in the 1930s. He said he described a situation where he had done a very careful analysis of a field trial, and he had sent it up to Yates because he wanted to present the results to the staff, and Yates sent it all back. Cochran pointed out that although he had done an elaborate analysis, not very many effects turned out to be significant, and that he had really had to tease out these very carefully tease out these interaction effects. And Yates sent it back with one sentence written across it saying, crop failed. You have to know what you're doing in analyzing an experiment. You have to know what you're doing in analyzing a survey. You have to know what you're doing in understanding what's going on in a case. If somebody's going to ask you to be a witness on, in the case that I worked on the 3M Corporation in Minnesota, you better have gone to the plant so you know where the clerical workers work, where the production workers work, if that's what's at issue. Even if that doesn't enter into your chi-square test or regression analysis, it's very important to understand the context. It's very important to have looked at the application forms rather than simply do an analysis of the numbers that appear thereon. Let me tell you why it's important, because that's where the smoking gun is in the discrimination case. In the 3M case, which has since been settled, the lawyers never looked at the applications, and we were given a box, and I sifted through the box with a junior colleague with whom I was working, and we came across an application of a female. The issue here was production workers being assigned to two different kinds of jobs, and then there was the clerical workers, and they got even less pay, and they were all female. And scrawled across the application form for a production job was, cute, has nice knees, put her in my department. And when that piece of paper went to the other side as an exhibit, they suddenly began to want to talk settlement because they suspected that we had lots more. And the lawyers never found that. The statisticians found that. And that was much more persuasive than the elaborate analyses that we had done for the lawyers in the case, because they decided that that was worth their attention looking at. And that's the kind of anecdotal evidence that we found there. But I think that there's more involved. I think that if you're going to take this kind of thing seriously and go beyond testifying in one case, it's like anything else. You have to learn something about the law. In the same way you have to learn something about agriculture or something about psychology or sociology or crime or whatever it is you're working on. And I pulled out my paper with Myron Straff that I promised not to use tonight, and I thought I would read you a quote, and maybe this is an apt way to end. We were noting throughout the paper that there's an interplay between the law and statistics. And if statistics as evidence in this process is to contribute to the resolution of conflict, it must do so by serving the process effectively. To this end, statisticians must be more accepting of their science being used in ways that serve the legal process well. Statisticians should not necessarily expect to impose the rigor of their discipline for scientific relevance, completeness, and accuracy in generality on the courts, and they may need to become more tolerant in the following aspects of the legal process: the selection of evidence according to legal standards of relevance, the expression of ideas in somewhat vague and imprecise terms, the reformulation of statistical concepts into words that can take on new and different meanings, the inference of conclusions not from proofs, logical consequences, or even statistical tests of significance, but rather from impressions and assessments of reasonable experts. And finally, the acceptance of a statistical method, not so much on the basis of an evaluation of the method itself, but more on an ascertainment that the method has found acceptance in the scientific community. That's a big mouthful for most statisticians to swallow, and explains why some of them do well in courts and some of them don't.